Hello everyone, welcome to this Privacy Rules flash briefing. I'm Kim Walker, partner in Shakespeare Martineau in the UK. This briefing concerns an important recent decision of the Supreme Court in England on when an employer should be directly liable for the wrongdoings of their employee, even though the employer has had no part in the wrongdoing and is entirely blameless. In the UK, this concept is known as vicarious liability, and it is based on the principle that an innocent victim should have recourse against a financially responsible employer when the actions of an employee cause them harm. It's an interesting case for all business lawyers, but it's particularly interesting for data protection lawyers and those interested in data protection because the case relates to breaches of data protection law by an employee. It's important for businesses. It was particularly important that the Supreme Court decided what it did because it overturned some decisions of the lower courts in the same case, which held that the company involved, which is Morrisons, a very large UK supermarket group, was vicariously liable to various claimants for the wrongdoings in terms of data protection breaches carried out by one of Morrisons' employees. This would have cost Morrisons a very large sum potentially in terms of compensation to claimants for data protection breaches, and this would have been the case even though Morrisons was entirely blameless in the problem, in the issue. So the decisions of the lower courts were worrying for British businesses and lawyers, and the Supreme Court decision was welcome. And that is why the decision was taken right up to the Supreme Court. The facts were Mr. Skelton, who was an internal IT auditor at Morrisons, employed to help with the annual audit. He was unhappy because he had been disciplined for some relatively minor offence, and he bore a secret grudge against Morrisons. As part of his job, Morrisons gave Mr. Skelton the payroll details of about 120,000 Morrisons employees as part of the annual audit process. Mr. Skelton, in fact, copied those data, those personal details, onto his personal computer and then uploaded them to the internet in revenge for the disciplining that he thought was unjustified by Morrisons. Mr. Skelton was eventually found guilty of a number of offences, including data protection breaches, and ended up in prison. The ICO, however, found that Morrisons was blameless. It wasn't in breach of the data protection laws at the time. Nevertheless, a large number of Morrisons employees brought a class action, a representative action against Morrisons for compensation for distress caused by the leaking of their data onto the internet. Lower courts found that Morrisons were indeed vicariously liable to the claimants for Mr. Skelton's wrongdoings. The fact that Mr. Skelton was at the time the data controller didn't let Morrisons off the hook. It could still be vicariously liable. They'd entrusted Mr. Skelton with the data, so they took the risk, in the court's view, that he might misuse it. His role was to store the data, and disclosing it online was closely related, said the court, to what he was employed to do. And the fact that his motives were malicious was irrelevant. And the Court of Appeal agreed with that, with the lower court, the High Court. The Supreme Court, in a decision released fairly recently, took a different view, however. They felt that the enterprise theory, which is really the basis, or one of the bases, for vicarious liability, that people who set up businesses in order to make money should bear the risks associated with employing people, they felt that this enterprise theory had run amok, run too far, gone too far. It was out of control, and innocent employers were finding themselves liable for excessive liability. There were two matters to consider. What was the employee's field of activities, and were the employee's actions closely connected with those activities? In Mr. Skelton's case, they decided that his activities were not closely connected to what he was employed to do. Just because by giving him data, they gave him the opportunity to misuse it or to carry out the wrongdoing, this didn't mean it fell within activities he was authorised to carry out or that were in his capacity as an employee. His motive was indeed relevant. They said that it was a personal vendetta being carried out by Mr. Skelton and not business that he was engaged in on behalf of his employer. His field of activities, they said, involved holding data and providing it for audit purposes. It didn't, or his field of activities didn't comprise holding data and doing what he wanted with it for his personal reasons. The Supreme Court distinguished the previous leading case on vicarious liability, which curiously enough also involved Morrisons, but in this case a Morrisons service station. An employee at one of their service stations had assaulted a customer, and Morrisons had been found vicariously liable. In that case, the employee was employed to look after customers. The fact that he did it in a violent way didn't alter that fact. He was going about his employer's business when he assaulted the customer, albeit in a rather unconventional manner. Mr. Skelton wasn't. He was pursuing a personal vendetta, and that wasn't related to what he was employed to do. The fact that the employer gave him the opportunity to commit the wrongdoing wasn't enough, just as if they had provided him with a gun and he'd shot someone. That wouldn't have been enough for them to be vicariously liable for his actions. So this is a welcome decision for employers, especially in the fields of data protection, where representative actions, as I say, mean very large sums of money can become payable. Employers should be very careful, but they shouldn't ignore the possibility of being directly liable for data protection breaches. For example, if they allowed Mr. Skelton to have the data for longer than he should have had it, or beyond the time they should have deleted it under the data minimization principle, then Morrisons might well have been directly liable for breaches of the Data Protection Act, in fact, for unlawfully processing the data through Mr. Skelton. But overall, it's a reassuring decision for businesses in the UK, and it's made the law on vicarious liability a good deal clearer. Thank you for listening.